Okay. Well, thank you so much.
Okay, good. Now, sick leave, like I said, doesn't get paid over. It doesn't get carried over and doesn't get paid out. And an employer is entitled to request from every employee a sick note from a doctor or a hospital or a clinic if you are away from work for more than 2 days. Okay? They are also entitled to request a sick note if there is a pattern that has developed that shows that you are sick continuously. For example, employees get phantom illnesses before a long weekend, after a long weekend, payday, a Friday. They get very sick all of a sudden. If there's a pattern of that for any particular employee, all right, an employee can say, well, you're quite ill, man. You seem to be getting sick very often here. Every Friday you're sick. Every long weekend you're sick. The day after a long weekend you're very sick. The day before you're very sick. Payday you're sick. If there's a pattern that develops for any particular employee, that employer is then entitled to ask this employee every time that they're ill to produce a sick note, because clearly being away from work so often, there must be something wrong with you. And an employee is entitled to ask you that, are you visiting a doctor? Are you getting the necessary help? Okay? So please be wary that even though the provision says that for more than 2 days, an employee is entitled to ask for a sick note, if there's a pattern that is showing that this employee is continuously staying away from work, an employer is entitled to ask for a sick note on every day that that employee is away from work. Okay. Now, the other thing about sick leave, because you do not carry it over and because it doesn't get paid out, you find sometimes that that employees actually, because they're losing out, they believe they're losing out on this, they start getting fraudulent sick notes from doctors' surgeries. They go to the receptionist has the doctor's pad there, and they give you a sick note. Because remember, if you don't take sick leave, you've got to go to work. If you're not sick, you've got to go to work. It doesn't get paid out. So some employees decide, we're going to lose the sick leave. Let us get the doctor's note somewhere, and to get more than 2 days sick leave and whatever else have you. So they go and get the doctor's note. They get a note from the receptionist. Now, let's assume you're one of those employees who do this. An employer is entitled to phone the doctor and ask the doctor whether or not they had consulted you. Okay, whether the doctor had seen you and had consulted with you regarding your illness. And if it is found that you hadn't consulted the doctor says, I have no knowledge of this, I don't have it on my files, you're going to be charged for fraud, because that is fraudulent. And then you will be more than likely be dismissed, because what you've done is fraudulent. So please be careful about trying to get sick notes from receptionists, doctors, secretaries, and whatever else have you, because if you are caught out, you're going to be fired for fraud. And interestingly enough, these doctors, receptionists make a business out of this. For 1 day, if you want 1 day sick leave extra, they give you 50, you have to pay them $50, and so it goes on. 2 days, 75, 3 days, 100. But please be careful about getting sick leave notes, knowing that you are not ill, and simply buying it from the doctor's surgery or whatever else have you. You will be dismissed for fraud. Okay, good. Let's move on. We did annual leave, we did sick leave. Let's do family responsibility leave. You know what family responsibility leave is, right? Family responsibility leave, it's 3 days per annum, not 3 days per event. Okay, it's per annum. Now you take sick leave, if there's a death in the family. And when we talk about family, it actually, the basic condition stipulates what they determine and who you can take family responsibility for. It's a husband, a wife, a spouse, a partner, a child, a grandchild, a grandparent, an adoptive parent, and so on. It is very specific as where you can take family responsibility. You can't just simply take family responsibility leave for a friend. because a friend has passed on, or you need to take a friend somewhere to the doctor and so forth, is actually quite specific as to when you can take family responsibility leave. Okay, now family responsibility leave, it's 3 days per annum, but doesn't have to be taken as a whole. You can take it in part. For example, if you have a child and you need to take a child to the doctor, it may take you 2 hours to go to take your child to the doctor. Do you understand? You can take 2 hours of family responsibility leave. So you'll still have your allocation of 2 days and 6 hours of family responsibility leave still left over for when you really need to take the child again, or parent, or to attend the funeral of a close relative, or whatever else have you. You don't have to take family responsibility leave in whole, as in a complete day. You can take it in part. Okay. For example, in my culture, if somebody passes on, the ceremony and the funeral is done very, very, very quickly. I mean, I can go and attend the funeral now for hours, and I can go back to work at any time. So there are. You can take it in part. You don't have to take it in whole. All right. That's family responsibility leave. There was a very interesting case that had come up with regard to family responsibility leave and what people determine as a parent. Now, you'll find in certain cultures where a person may have two sets of fathers or two sets of mothers. And the reason for that is the way in which they title them. So one is a biological parent, but the other parent is the person who actually looked after them when they were young. So you do find that sometimes people send their kids away to be looked after by an uncle because of certain circumstances, or by a grandparent, or by a close family relative, and people would call those people who looked after them as my father or my mother. So they have essentially two sets of parents. And what happened is that there was a guy who had taken family responsibility leave to attend a funeral. And on his sick leave note, he says, "Death of my father." Now, obviously, the person who had passed on didn't have the same surname as him, so the company became very suspicious of this. Okay? And when they investigated this, they say, well, this is not your father, and therefore you had fraudulently sought to take family responsibility leave. When he came to the inquiry, he said, but wait a minute. I called the person who passed on my father because this is the person who looked after me my whole life. I have a biological father, yes, but this person who looked after me, that is my father. And in my culture, we'll call this person father out of respect. So when I put that thing down on the leave form, I had to write father. Yes, I agree. He's not my biological father, but this is my father. He's my uncle. He's my close relative. I had to attend the funeral. So sometimes you need to be wary of this, that there may be certain titles given to certain people. Okay, it doesn't mean that the person is trying to be fraudulent. Is that in certain cultures, certain titles are given to people because of what they've done. So this uncle who's looked after this guy over the years, from when he was little, had become this guy's father. And that's why when he put it down, it's his father. All right. So just be wary of that. Culturally and so forth, people have titles for people. So just be wary, okay, as to what this means. All right. Let's move on. Let's move on to maternity leave. Now, person is entitled to 4 months. Well, ladies are entitled to 4 months maternity leave, 1 month before date of delivery and 3 months thereafter. So essentially, there's 4 months of maternity leave that an employee is entitled to have. This maternity leave is not paid. There's no obligation in law for the employer to pay the maternity leave, but employees can claim UIF benefits. All right, so they can go to Department of Labor and claim UIF benefits, and you probably get about 60% probably of your salary from UIF. Okay, now if there's a stillborn child, okay, sometimes there are stillborn children you are entitled to 6 weeks after the birth of a stillborn child. All right. Now, there are many households where the lady, the mother, is the primary caregiver. Well, she is the primary caregiver, but is also sometimes the sole breadwinner in a house. I mean, there is no other support. And you'll find that employees who go on maternity leave want to come back to work as quickly as possible because they need to start earning. All right. So you'll find that people want to come back earlier, and there's nothing wrong with that. As long as it is safe, and the doctor tells them that it is safe for them to come back to work, they can come back to work. Now, I'm going to give you a case that actually illustrated this issue about whether or not employees can forfeit their statutory provisions in terms of the basic conditions. So there was this lady who was going to go on maternity leave. She worked for this company, and she was going to come back a little earlier and not take her full allocation of maternity leave. Firstly, because she needed to come back earlier and she needed the money. And secondly, is because an employer spoke to her and said, look, operationally, we can't allow you to be off for the complete duration. So would you please consider coming back a little earlier if you don't mind? And she said, look, I'll come back earlier. I don't have a problem. In fact, I need to come back earlier because at least I'll get paid. And I'll earning again because I don't have any other means of income. And so they entered into an agreement. It was a written agreement to say that she would come back earlier and not take her full allocation of maternity leave. All right. So the lady goes on maternity leave, and when it's time to come back, she can't come back on the time that she'd agreed to because she had thought that she would have been able to arrange a caregiver and so forth, but she was unable to. The caregiver that she wanted, the deal didn't fall. It fell through. Nothing ever happened of it, and she was stuck, and she wasn't in a position to go back to work and leave her kid anyway. So she phones the employer and says, "Listen, I can't come back to work in terms of the agreement, even though we had agreed that I would come back earlier. I can't. So please, I need to take my full allocation of my maternity leave." And the employer says, "No, you signed an agreement with us that you would come back. We were dependent on you. You knew there was an operational need. We even asked you and you said it was fine. You can't. You have to come back to work." Okay, she said, "No, I can't." Coming closer to the time, she sends them again and says, "Listen, I can't." The employer says, You will come back to work." Anyway, on the day that she's supposed to return to work, she doesn't come to work in terms of the agreement, okay? The employer sends a telegram and says, in terms of the agreement that we had signed, you were supposed to have been at work by so-and-so day. You have not come into work. Please report for duty. She doesn't come. 2 days later, the employer sends her another one and says, "You haven't reported for duty. Herewith is a notice to attend an inquiry for being AWOL, absent without leave, permission, and we're going to have an inquiry in your absence if you don't come." She doesn't go to work. They have an inquiry in her absence, and they terminate her services. Okay, she's get dismissed. She then refers a matter to the CCMA, and because it's a matter relating to pregnancy in her view, the matter has to go to the labor court, all right, because of jurisdiction. Now, the labor court firstly had to determine whether this was a matter relating to pregnancy or not. And they tick that box very quickly because maternity is only as a result of pregnancy. It is a matter relating to pregnancy, okay? So they tick that box. But the more important question that needs to be answered is, can an employee forfeit their statutory right, okay, and then claim it, even though they may have signed a contract? Now, the court viewed this very seriously, because it's not an easy question. Because I'm entitled to, as an employee, to say, I don't want to take, I want to come back to work. All right? But the question arises that even if I do that, and I really need to take my statutory provision, am I precluded from taking it because I've signed an agreement? And the court said no. If you have signed an agreement, even if you have signed an agreement, especially in this instance relating to maternity leave, but you cannot keep to that agreement, you are still entitled to take your statutory provision, because by law, you are entitled to take your complete provision of maternity leave. And an employer cannot bind you to a contract where they ask you not to take your full statutory provision. Okay, so in this instance, the court said it was wrong, the dismissal was automatically unfair, and they awarded this lady 20 months compensation. Okay, now our courts don't play when it comes to maternity, to reasons relating for pregnancy and so forth. They view it very strictly, and the important principle is that a person cannot, when it comes to maternity leave and so forth, cannot simply sign away their statutory right. All right? Okay, good. So that's maternity leave. What next? Let's see. Hours of work. 45 hours maximum a week. Employees, for every 5 hours that an employee works, the employee is entitled to take an hour rest break. For every 5 hours that they work, it's a 1 hour rest break. If an employee only works 6 hours a day, then they don't have to work 5 hours and then take an hour break and come back and work the 1 hour. No, they can work the complete 6 hours and just simply go home if they are working 6 hours a day. Now, what you do find is that that hour is not included as part of a working hour, right? It's not counted as part of a working hour. What happens though is that employers and employees get into an agreement where you'll take 15 minutes off for tea in the morning, you take half an hour of lunch, and then you take another 15 minutes in the afternoon, and that's how they calculate this hour. Because there is no provision for tea time in the basic conditions. I haven't seen that provision that you take 15 minutes tea time. But what they do talk about is a rest break of an hour for every 5 hours worked. But employees and employees get into this arrangement where they do 15 minutes, half an hour, and 15 minutes, and that's how they work out and they calculate this hour, because it seems to suit the parties better that way. In the absence of such an agreement, then it's 1 hour rest break. If an employer and an employee agree to half an hour of lunch without those 15 minutes either side, then that half an hour of lunch is actually calculated as part of working hours. All right? So just be wary of that. Overtime, an employee cannot work more than 3 hours overtime a day or 10 hours a week. All right? Overtime is also paid at 1.5 times the normal rate of pay. It will, however, be double on a Sunday or on a public holiday. If you are asked to work on a Sunday or public holiday, you'll be paid double, unless you ordinarily work on a Sunday, then it becomes 1.5 times that you get paid in terms of overtime. Okay. Now, you can also average out overtime over a period of 3 months. Now, what I mean by this is as follows. We've stated that you can't work more than 10 hours overtime a week. All right. For purposes of this calculation, we're going to assume that a month is 4 weeks. All right. The correct calculation, though, of a month is 4.33 weeks. Okay. So please remember this, that if you ever want to calculate a month in terms of weeks, it's 4.33, because 4 weeks only gives you 28 days. All right. And it's only 1 month in the year that probably we have 28 days. So when you calculate a month, it's 4.33 weeks. But for purposes of this calculation on overtime, I just want to work it out simply, because we say that you can't work more than 10 hours a week overtime. But an employer can average out overtime over a period of 3 months. So let's say I have an operational need where I need to have employees working overtime because I have new goods coming in, it seems to be busy season, and so forth. So I tell them in the first week, you guys work 15 hours of overtime. In the next week, you guys work 12 hours of overtime. The week thereafter, you'll only work 8. The week thereafter, you'll work 6. I'm averaging it out over a period of 3 months, as long as I don't go beyond the 120 hours, okay, of overtime. Yeah, correct. Do you understand what I'm saying? If you can't work more than 10 hours a week. So every week, in a month, there'll be 40 hours. In 3 months, it will be 120 hours. You can average it out of 120 hours over those 3 months, as long as you don't go beyond the 120 hours over those 3-month period. All right. So in a week, you may work 15, other week you may work 11, 12, other week you may work 10, other week you may 6, but you average it out as long as you don't go beyond the 120 hours in the 3-month period. So you average it out. All right. Okay. Ridwan, you there? Hello, Ridwan. Are you there? All right. Where's my friend? He's not here. Let's see. Cecilia, are you there? Hello? Anybody?
Yes, sir.
Hi, Cecilia, are you there?
Yes.
Okay, Cecilia. The time now is 9:32. All right? I'm going to give you a 10-minute break. I'm going to be back at around about 9:42, and we'll continue from there. Is it fine?
Sorry, sir, I couldn't hear you. There's a feedback. I'm not sure. I think Kakiso and Museto's mics are on, so we're getting a feedback.
Okay.
Yeah.
So let's just say whoever has their mics on, can you please put them off? All right?
Okay, can you speak again?
Yeah. Okay, good. So I'm going to take a 10-minute break, and we'll be back at it. Let's say, okay, let's make it a 15-minute at 1:45. All right? It's 9:33 now. At 9:45, we start again. Ridwan, is that fine, Ridwan?
What? Please repeat, sir.
I'm taking a little break till 9:45. Is it fine?
Fair. Yes.
Yes.
You can go and grab your tea, coffee, cornflakes, and Milo and whatever else have you, and I'll see you at 9:45. Oh, we'll chat at 9:45. Okay, sure.
Thank
Okay, hello everybody. We're back. Yeah. Hello, Cecilia, are you there?
Yes, I'm here.
Okay, we're back now, right? Okay, let's carry on. Okay, good. Let's move now to the Labor Relations Act, all right? Let's talk a little bit about the Labor Relations Act. Now, Labor Relations Act essentially is broken up into collective labor law and individual labor law. Collective labor law deals with the rights of unions and so forth, and employers' organizations. And individual labor law deals with individuals and rights that individuals may have and employers may have in terms of termination and unfair labor practices and so forth. Okay, now you all know what a trade union is, right? A trade union is an organization that essentially looks after the rights and interests of employees within organizations. An employer organization is an organization that looks after the interests of employers. You must remember that every employee has the right to join and participate in the activities of a trade union. You cannot dismiss any employee for belonging to a trade union. It is automatically unfair to do so. When we talk about unions and collective labor law, it's important to understand one or two concepts, one or two definitions, so that you know when I use these words, you must understand this. The first thing is we talk about a collective agreement. Now, a collective agreement is an important thing because a collective agreement is an agreement signed by a trade union and an employer or a number of trade unions or an employers or employer organizations that regulates the terms and conditions of employment. Collective agreements are very powerful agreements. They can sometimes even change the law or the rights that employees or employers may have. And they are binding on employees and employers the minute a collective agreement is signed. Now, you must also understand that we have different industries in the country. You know that there's a CCMA, which is a general body where people can go and refer disputes and so forth. And then we also have what we call bargaining councils. And you have different bargaining councils in the country for different industries. Not in the country, we have different bargaining councils for different industries. So, for example, we'll have the motor industry bargaining council, which deals with the motor industry. People who have garages, who sell spare parts and so forth in terms of motor cars and that's the motor industry. We have the National Bargaining Council for the chemical industry, which deals with employers and employees who are employed or who work in the chemical industry. And we have the metal engineering industry bargaining council and so forth. So we have a number of different bargaining councils. We also have different bargaining councils in the public sector. You have the health and welfare sector bargaining council, you have the police, safety and security sectoral bargaining council, and so forth. These deal with specific industries. Okay. So for example, if we take the motor industry, people who belong to the motor industry, they will negotiate terms and conditions more often than not within the bargaining council, and whatever is agreed to there gets filtered down to all employers and employees who work in that industry. All right. So it's like a mini CCMA, but for a specific industry, except that they also negotiate terms and conditions of employment. So that's a bargaining council. You know what? So if they enter into an agreement at a bargaining council level, that agreement becomes a collective agreement, which binds all the parties to that industry. All right. Okay. Now, let's say you have a little company and you get a visit from a trade union official. Trade union official comes there and he says, listen here, there are some of your employees who have become members of our trade union, and we therefore want to be recognized by you as the employer as the official bargaining agent for all these employees. So we want to be able to negotiate on behalf of these employees in your company on terms and conditions and so forth. All right. Now, the first thing that you will do is that you will ask the trade union for a certificate of registration. For any union to enjoy any rights in terms of the Labor Relations Act, they must be a registered trade union. Now, trade unions get registered through the Department of Labor. They have to comply with certain provisions of the Department of Labor before they can be recognized and be registered as a trade union that may have rights in terms of the Labor Relations Act. Okay, so the first question is, or the first thing you'll ask for is certificate of registration. Now you'll find that the Department of Labor, I think it's every 6 months or every year, I think it's 6 months, publish a list of registered and deregistered trade unions. Okay, so unions that are registered, who comply with the provisions set down by the Department of Labor, and they are registered and they're entitled to enjoy the rights. But you have those unions who may have started off as trade unions and they were registered, but simply do not comply with the provisions of the Department of Labor. They become deregistered. So they no longer enjoy those rights that the Labor Relations Act gives to them. Okay, so they become deregistered. This next thing you'll ask for is the constitution of the trade union, to find out exactly what does the constitution of the trade union say, how do they go about doing things, and sometimes is in which industry is a trade union acting. Now, you'll find a lot of the trade unions, or some, I shouldn't use the word a lot, some of the trade unions restrict themselves to activity within particular industries. Let's say that we're only going to be organizing in certain industries, the motor industry, the metal engineering industry, the clothing industry, wholesale and retail, and so forth. Now that becomes important because you want to know whether or not the union has restricted themselves to a particular industry, or you have some unions who have actually opened up wide enough to allow themselves to organize in different industries. And that becomes important when we talk about certain organizational rights only. All right. Generally, trade unions can organize anyway. They can get membership anyway. Okay. So you ask for their constitution. The next thing you'll ask for those membership forms. When they say some of your employees are members of the trade union, then you ask for a membership form. So on that membership form, it will be the name of the employee, and obviously there'll be stop order, facilities, or whatever else have you, and what is the trade union membership. Now, you find some trade unions have as the membership fee, it's 1% of a person's salary, or maybe more, but they limit it to X amount of money. So for example, you pay 1% of your monthly salary to the trade union as a subscription, maximum up to a maximum of 100 Rand or 60 Rand or 80 Rand, depending on the trade union. Okay, so there's membership fees that need to be paid. All right. Now, one needs to learn to distinguish, because certain rights are given to trade unions, and one needs to distinguish between what we call sufficiently representative and majority trade unions. Now, sufficiently representative, there is no formula as to what sufficiently representative is. But what we do is that we look at something between, let's say, 30%, sometimes it's 20%, sometimes it's 15% of the workforce who are members of the trade union. And if they have that amount in a workplace, then they're entitled to certain rights. Obviously, a majority has more rights. If you're a majority trade union, okay, then you're entitled to access to information, you're entitled to what we call shop stewards, trade union representatives in the organization, and how you work out how many shop stewards you are entitled to is dependent upon the numbers of employees that are members of a trade union. So for the first 10, you'll have one shop steward. Then up until 50, there'll be the second shop steward, and it goes on like that. There's a formula in the Labor Relations Act that tells you how many shop stewards a trade union is entitled to have. Now, a shop steward is a union representative in the workplace. This person is employed by the employer party. Okay, so they're working there, and they've been elected by the members of the trade union. Those employees who are members of the trade union, they've been elected by them to serve as the shop steward in the organization. Okay, now when a union is registered, has sufficient representation and so forth, always a majority union, they get certain rights. One of the rights is to enter into a workplace, to organize, to have meetings and mutually agree to times. They're entitled to stop order facilities. That means that the employer will deduct from the salary of employees the union subscription and pay it over to the union, and then every month give a remittance as to who the employees were and how much was deducted. If you're a majority trade union, you're entitled to shop stewards. You're entitled to access to information in terms of Section 16 and so forth. So there's certain rights that are given to trade unions depending on whether they're sufficiently representative or they're majority trade unions. Okay. Now, sometimes you'll find that trade unions like to organize in particular bands only. So if I were to give you an example, let's just say there's an organization and we have from level 1 to level 10, okay, different levels in the organization, one being the executives, okay, executive managers and so forth. And as you go down, it becomes senior managers, middle management, junior management, technically skilled employees, so on and so forth. And we come down to rudimentary skills, semi-skilled and so forth. Some unions have a lot of their membership sitting in different areas in an organization. So if there was a trade union that came in and said that they only like to organize in, let's say, 8, 9, and 10, levels 8, 9, and 10 in an organization, they can do that. And what they also do is that they ring fence those levels, and they say that we are negotiating for employees in these 3 levels. And they call that 8, 9, and 10, they call that the bargaining unit. All right, so that's the unit that they're going to be negotiating for. And they have discussions, negotiations on terms and conditions with the employer party for those employees in those units. Now, what happens very often is that if I'm negotiating as a trade union on behalf of my members in levels 8, 9, and 10 in that bargaining unit, when I get into an agreement, that agreement will apply to all the employees, even if they're not union members in 8, 9, and 10. So if I agree to a 5% salary increase or 10% salary increase or whatever it is, that will apply to all those other employees in that bargaining unit. All right, so you could extend it to non-union members as well. All right, now, if a union is a majority in a bargaining unit, they can enforce certain rights or enter into certain agreements. So let's just work it out this way. I'm a union. My bargaining unit is 8, 9, and 10 in an organization, right? And as a union, we have the majority of employees in 8, 9, and 10 as members of the union. All right, so it's only that bargaining unit. I'm not talking about the whole organization now. All right. Or there's more than one union and jointly they come together and jointly they have a majority of employees as members of their unions together. Okay, they can then enter into agreements with the employer party. Okay, the first agreement we talk about, I think, is Section 25 of the Labor Relations Act, which is called an agency shop agreement, where it says where a union is a majority or one or more unions acting together have as a majority the employees in that bargaining unit, they can enter into a collective agreement with an employer called an agency shop agreement, where all non-union members must pay an agency fee to the trade union. Okay, Cecilia, are you following me?
Yes, sir.
Okay, So we have a majority, one union or more than one union, they act together and they say, listen here, we have the majority of employees in this bargaining unit. The rest of the employees must now pay an agency fee. We can enter into a collective agreement called an agency shop agreement, where non-union members must pay an agency fee. Now, this is what we call a union security arrangement. Okay, remember, when unions negotiate in that bargaining unit, non-union members get the benefit thereof as well in terms of the terms and conditions of employment. So when there's salary increments, they would get it as well. So here, non-union members are required to pay an agency fee. It's like, you know, you're jumping on the bus, but you don't pay the fare. All right. Now here, you will have to pay an agency fee to the trade union if you are a non-union member. Now that agency fee can never be more than what a normal union member pays. So let's say union members pay 80 Rand a month. These people who have to pay the agency fee now, these employees who are not members of a trade union, cannot pay more than 80 Rand a month as well. Okay. However, these employees who have to pay an agency fee can direct that their monies be paid over to the Department of Labor for the Department of Labor to administer instead of it going directly to the union. Now, the reason for that is that this agency fee cannot be used for any political purpose. Okay, you can't use it for any political purpose. So if you decide, if those employees decide that their monies must be paid over to the Department of Labor, then the Department of Labor administers the money. And if the unions want money out of there, they must then apply to the Department of Labor and make sure that those monies are not used for any political purpose. All right. Okay. So that's an agency shop agreement. Now, again, there's another provision, Section 26, which is called a closed shop agreement. Here again, one or more than one union acting together have as their members the majority of employees employed working in a particular bargaining unit. They can enter into a collective agreement with an employer called a closed shop agreement. Now, a closed shop agreement is different to an agency shop agreement. But before a closed shop agreement can come into being, there needs to be a ballot, a vote, okay, where 2/3 of the employees in that bargaining unit must vote in favor of a closed shop agreement. If you don't get a 2/3 vote in favor, you cannot have a closed shop agreement. Now, a closed shop agreement essentially means that all employees must now belong to the union. Not only the agency, not only paying subscription as in an agency fee agreement. Here, the employees must belong to the trade union. All right. Now, it would seem as though this is an infringement on a person's freedom of association. But this has been tested and it's not an infringement. It's a union security arrangement where employees who are majority and who have voted, and 2/3 have voted in favor of closed shop agreement, seems to be fine. There is no problem with it. And all non-union members now need to belong to a trade union. You can, if you're one of those employees who are not a member of the trade union, and now there's a closed shop agreement, you can choose not to belong to the trade union if you are a conscientious objector. That means that your conscience doesn't allow you to join this trade union because of what these trade union policies, objectives, and purposes are. Okay, and I'm going to give an example, and it's a silly example. Let's assume that this trade union advocates for abortion. Okay, in terms of your conscience and your religion, you cannot have abortion. You can then become a conscientious objector and say, I'm not going to belong to the trade union because I'm a conscientious objector. However, you're still going to have to pay that union membership fee. Okay, you're still going to have to pay that fee. All right. Here again, those employees who have to join the union under closed shop agreement can direct that their membership fees be paid over to the Department of Labor, similar to the agency shop agreement, all right, where the Department of Labor administers it. Now, the reason why this is so is because collective agreements have a lifespan. They have a lifespan of a year, maybe 2 years. Now, let's assume that the union or the unions acting jointly no longer have the majority. Then the employer can send a notice to the unions to say, you don't have a majority anymore. We're going to be cancelling this closed shop agreement. Do you understand? So it's not something that is in perpetuity, that has to be there all the time. If the unions don't make the numbers anymore, right, then that should fall away. So they can cancel the collective agreement. Right? Similar to the agency shop agreement. Collective agreements have a lifespan. And once that time period is over, they fall away until a new one is entered into. Or the requirements are not met. For example, in agency shop and closed shop, you need to have majority. Now, if there is no majority, all right, then that collective agreement can be terminated. All right. Now, the interesting provisions in the closed shop agreement, they seem to be quite harsh. The first one that I'm going to talk about is the following. It says that it is not unfair. It is not unfair for an employer to terminate the services of an employee who refuses to belong to the trade union in a closed shop agreement. So we told you that a closed shop agreement is where employees have to belong to the trade union. If you refuse without being a conscientious objector, then the employer can terminate your services. It's not as easy as simply saying termination. There's a process that needs to be followed, but your services can be terminated because you refuse to belong to the trade union under a closed shop agreement, and the law says that you must belong. The second thing is that it is not unfair for an employer to terminate the services of an employee who no longer is a member of the trade union under a closed shop agreement. Now, every organization, whether you belong to a tennis club, a soccer club, a trade union, a political party, whatever it is, every organization has a constitution. In those constitution, they put down rules of conduct. If you break those rules of conduct, that organization is entitled to take action against you, and they may even expel you from the organization. So if you remember a number of years back, Juju was a member of the ANC. They had then taken him to a disciplinary inquiry for certain things that he had done, and he had been expelled from the party. Okay, so any organization can do that. Now, let's say you are a member of this trade union in a closed shop agreement. You go and do something which is against the union constitution or against the code of conduct of the union. The union is entitled to take disciplinary action against you. And if you are found guilty, the union can take action against you. And if that action means we are expelling you from the union, then the employer can terminate your services. Because remember, you can no longer be a member of a trade union in a closed shop agreement. All right? So there are those provisions in the Labor Relations Act dealing with agency and closed shop agreement. They seem to be a little bit difficult for certain employees, but I must be honest with you, very, very, very rarely get closed shop agreements in the country. We do get agency shop agreements, okay, but you don't have to belong to a trade union. You just pay over the subscription fee. We don't have many closed shop agreements. There's very few, very, very, very few closed shop agreements, okay? And those clauses in there, as draconian as they sound, there's a process before there can be a termination. But what a closed shop does do is that if a person wants employment in a particular company, up front you are told that there's a closed shop agreement. And if you're not going to belong to the union, we're not going to give you employment also. So it becomes a bit of a difficult thing for employees who want to get employment in an organization where there's a closed shop agreement, or and they're applying for jobs within their bargaining unit. They may not get employment if they don't belong to the trade union or choose not to belong to the trade union. All right. So just be wary of those provisions in the Labor Relations Act. All right. I'm going to now move over to another topic. You all fine so far? Yeah. Yes. There's a
Morning, sir.
Morning.
I just wanted to find out, are employers obligated to create trade unions, or is that something that only employees would create on their own?
It's an employee-driven initiative. And in fact, it's not an employee thing. Trade unions create themselves. People make or establish trade unions. Employers don't have to do anything.
All right. Thank you so much.
All right. Employees want to belong to trade unions. People get together, decide, let's open up a trade union. They open up a trade union. It's an employee-driven initiative. It's got nothing to do with an employer. Okay. Anything else? Anybody else have a question? Guys okay so far? Yeah. Cecilia, are you fine?
Yes, sir.
Okay. So Cecilia, since I'm not on camera, I'm going to drink some coffee now, right? Just give me 10 seconds.
Okay.
Okay. Shall we move on? All right. Let's talk about strikes. All right. Yeah. Every employee has a right to strike by law. Okay. It's a right that is given to employees. However, having said that, one person cannot strike. There has to be more than one person. Okay, so there has to be two who can go out and strike. A single person cannot strike. All right. Now, further, remember that the right to strike is an employee right. It's not a trade union right. It's a trade union simply organize it or assist employees in going out and strike. All right. It's not a trade union right. It's an employee right. Okay. Now, we need to understand what the definition of a strike is. And very briefly, a strike is a partial or complete refusal to work by employees in order to remedy a grievance or to deal with any matter of mutual interest between the parties. And any reference to work includes overtime, whether it is voluntary or compulsory. Okay, so let's break this down. It's the partial refusal to work. That means even your go slows, people who go slow, they work a little bit, they go very slowly, they don't make the production. Go slows are also a strike. Or complete refusal. That means we completely stop working. All right, in order to remedy a grievance. Now, this may be a grievance, may be a collective grievance that employees have either against the company or against a particular manager in a company, which the employer is not dealing with. Okay, so it's to remedy such a grievance, or they're not happy with the terms and conditions of certain things, or whatever else have you, and they lodge an grievance and the employer is doing nothing about that grievance. Okay, so in order to remedy a grievance or to deal with any matter of mutual interest. Now, a matter of mutual interest is as follows. In our law, we have rights. If a person infringes your right, you go to court. Rights are different to interests. Interests are something that people want or they need. When people negotiate salaries, salary increases or changes to terms and conditions of employment, like I want more annual leave, or I want a housing allowance, or I want a transport allowance, those are interest matters. The law doesn't give it to you. Okay. Now, when it comes to salary increases, there's probably two sectors, maybe 2 or 3 sectors in our country where the law determines the salary increases. The first one is the domestic workers, and I think the farm workers and maybe another sectoral determination elsewhere, but that's about it. The law tells you domestic workers how much they need to be paid, what the increase is going to be every year, and so forth. There's nowhere else in the law that directs that a particular person must earn a salary of X amount. There's a minimum wage, but it's not a salary increase. Okay? So in a company, the law doesn't say you must give them 10% or so forth. That is a negotiated thing. It's a matter of interest. It doesn't exist in the law, but parties want it. So you'll find now that trade unions or employees, for that matter, will send a list of what we call demands to an employer party to say, okay, salary increase. We want 15% per annum salary increase across the board. We want a housing allowance of 200 Rand. We want transport allowance of 500 Rand. We want more sick days, sick leave. We want to increase our annual leave. We want maternity leave to be paid. So they send a list of demands to the employer party. The employer party looks at those demands and then they start negotiating. Okay? So the employer will say, no, we're only going to give you 2% salary increase. We're not interested in this housing allowance. There's no need for transport, and so on and so forth. And parties start negotiating. It may reach a point where parties do not agree on these points, or in terms of what should be given, what shouldn't be given, what the salary increase should be, and so forth. And that's where you get to a point where the unions or the employees collectively declare a dispute. Okay? That means that they haven't resolved this negotiation. They haven't resolved this matter. They haven't gotten what they're asking for. So they declare a dispute now. Now, in order for the employees to be able to get what they're looking for or close to what they're looking for, they need to be able to put pressure on an employer party. And the pressure that they exert is by withdrawing their labor. Okay? Now, let's say we've entered into negotiations. We've now reached a deadlock. What will happen then is that the unions acting on behalf of the employees or the employees as a collective will refer a matter to the CCMA, or if they belong to an industry that has a bargaining council, to that bargaining council. Okay? And within 30 days, that CCMA or that bargaining council must set up a conciliation meeting. The conciliation meeting is there to see if they cannot resolve that matter. So a conciliating commissioner will sit around the table with the parties and try and resolve the matter to see if they can't get into an agreement on something. Okay? Should there be no agreement, the CCMA commissioner will issue a certificate of non-resolution. That means this matter has not been resolved. Sometimes it does happen that the CCMA or the bargaining council doesn't set the matter down within the 30-day period. And if that happens, then either party can ask the CCMA or the bargaining council for a certificate of non-resolution, all right? Now we have a certificate of non-resolution. This is now the passport that employees can use to go out on strike. In the private sector, you'll give 48 hours notice of going out on strike. In the public sector, is 7 days notice to go out on strike. Nowadays, I see that there's an amendment to the act that says the employees must ballot to go out on strike and so forth. But you give notice to the employer party to go out on strike. All right. The minute you have the certificate in your hand, the certificate of non-resolution, your strike action now becomes protected. That means you are protected as an employee from being dismissed from employment. If you do not have that certificate of non-resolution, then your strike is not protected. You are not protected from being dismissed. Okay? So we have what we call protected strikes and unprotected strikes. Okay, if you have the certificate, it's a protected strike. You can go out on strike for as long as you want. Remember, when you go out on strike, there is no pay. An employer is not obliged to pay you when you're going out on strike. All right. Now, employees have the right to strike. They're putting pressure on an employer by withdrawing their labor to force an employer to give them what they want or to give them closer to what they want and so forth. It's putting pressure. Employees have the right to strike. Employers have what we call a recourse to a lockout. Now, a recourse to a lockout means we lock you out of the premises. There's two types of lockouts. One is an offensive lockout. That means you're attacking, okay? And the other one is a defensive lockout. Let's deal with a defensive lockout. A defensive lockout is a lockout in respect of a strike that is already happening. So let's say there's a strike going on at the company. Employees are in the premises, but they're not working. The employer can then lock them out of the premises. And that will be called a defensive lockout because it's in response to a strike that is already happening. Defensive lockout. In that instance, an employer can employ replacement labor. All right? If there's a normal strike that employees go out, an employer can employ replacement labor. They can employ replacement labor in a defensive lockout too. An offensive lockout is one where the employer takes the initiative. So, for example, we entered into negotiations, we've reached a deadlock, the employer goes and refers the matter to the CCMA Bargaining Council, and the employer gets the certificate of non-resolution. Now the employer locks employees out. Similarly, to an employee withdrawing their labor to put pressure on an employer party can lock employees out to put pressure on those employees to accept the offer that the employer is giving to them. Do you understand? All right? Now, in an offensive lockout, an employer is not entitled to employ replacement labor. Right? You can't employ replacement labor if you have taken the step of implementing an offensive lockout. Okay. So, Celia, you understand? You with me?
Yes.
Okay. Any questions so far on the strike? No? Okay. Now, it sometimes does happen that people just simply go out on strike without having got that certificate of non-resolution, without them having got that passport. They are now on an unprotected strike, or they call them unprotected or illegal strike action, okay? Because they don't have the certificate. They have not complied with the provisions of the Labor Relations Act in order to go out on a protected strike. If this ever happens, that employees go out on an unprotected strike, an employer is obliged to give the employees what we call an ultimatum. So essentially, the ultimatum will be in writing. You write down, you are on an unprotected or illegal industrial action. Please return to work. You take that, you write it out on pieces of paper, type it out, you give it to the union officials, and you throw it into the crowd. Sometimes you go with a loudspeaker and you read this out, and you read it out to employees. You are an unprotected industrial action. Your strike is illegal. Return to work. If you do not return to work, there will be action against you. Okay? That's ultimatum number one. If employees do not heed that ultimatum, the employer will send out a second ultimatum to say, you have not heeded the first ultimatum. You are still on unprotected industrial action or illegal industrial action. Return to work. Should you not return to work, we will have inquiries which may result in your dismissal. Okay. Now, the important, you either give 2 or 3 ultimatums. 2 is sufficient. Some employers go to the third ultimatum. What this means now is that you have informed the employees that their action is wrong, that there is unprotected industrial action. Okay? When you do have inquiries, you use the ultimatum to say, we have informed you, we have warned you, and your action is wrong. All right? So please don't think that if an employee goes out or employees go out on unprotected industrial action, you can simply dismiss. You have to send out the ultimatums first. Okay? All right. Now, there are certain categories of employees who cannot go out on strike by law. Right? For example, parliamentary services, they cannot go out on strike. Okay? South African National Defence Force cannot go out on strike. Employees who are employed in essential services cannot go out on strike. So ESCOM, they can't go out on strike. Whoever's in essential services, your doctors in the public service, your nurses, they are essential services. They cannot go out on strike by law. Now, essential service is a service which, if taken away, has an impact on the safety, the security, the health, and the well-being of the citizens of this country. All right? The South African police services also cannot go out on strike. However, there's a very interesting thing about the police. There are some people in the South African police services who are employed in terms of the Police Act. And there are some people who are employed in terms of the Public Service Act. Now, those who are employed in terms of the Police Act are essentially your active police people, the ones who go out and patrol, the ones who do investigations and all of those type of things. They are employed in terms of the Police Act. Those people who are employed in terms of the Public Service Act are essentially your administrators. Okay? They sit as receptionists, as secretaries, they do administrative work and whatever else have you. So they're employed in terms of the Public Service Act. Now, a number of years back, there was a public service strike, and the police also went out on strike. Okay, this matter then landed up at the Labor Court, and the Labor Court said, look, we need to draw a distinction between people who are employed in terms of the Police Act and people who are employed in terms of the Public Service Act. People who are employed in terms of the Police Act cannot go out on strike. Because if you take them, if they are allowed to strike, then obviously the integrity and the safety of the people and citizens of this country will be affected. You're taking away your policemen. Those employed in terms of the Public Service Act, if you take their work away, the safety of this country is not impacted. Okay? They are allowed to strike. So there was a distinction drawn in the police services on the basis of those who are employed in terms of the Police Act and those are employed in terms of the Public Service Act. All right, now, so there are certain categories of people that cannot go out on strike. Your spies and spooks, the security agency, they cannot go out on strike. However, the security agency are not even considered employees in terms of the Labor Relations Act. Okay, they have their own set of rules. All right, and we don't want to know who our spies and spooks are. Just imagine people are going out on strikes and tell them we are spies. Really, you wouldn't want to know who your spies are in this country, isn't it? You're no longer then a spy. Okay, so they're also not entitled to strike. Good. Now, there's a provision in the Labor Relations Act which says it is automatically unfair to dismiss an employee who refuses to do the work of a striking employee. Okay? So, Cecilia, you and I work in the same company. I'm going out on strike. You've decided not to strike. Right? The employer comes to you and says, Cecilia, do Ahmed's work. Cecilia, you say, no, I will not do Ahmed's work. The employer then dismisses you for your refusal to do Ahmed's work. That dismissal is automatically unfair. Okay? So an employer cannot dismiss an employee who refuses to do the work of a striking employee. All right? However, there may be certain exceptions to that, where the integrity of the business, the safety of employees may be at stake. In that instance, Cecilia, your refusal would be unreasonable. Okay? And they then may terminate your services. In the normal sense, they cannot force you to do the work of a striking employee. All right? It is automatically unfair to dismiss an employee who refuses to do the work of a striking employee. Okay. you're comfortable with strikes now. You know what a lockout is. You know what a strike is. Now, sometimes you'll get people coming to you if you do employment law. They tell you, I was dismissed uh, because I went out on strike. Ask the question very carefully. Did you get dismissed because you went out on strike? Firstly, was it a protected or unprotected strike? Or second, and more importantly, what did you do during that strike? Very often people get dismissed not because they went out on strike, is because of their conduct during that strike. All right? The right to strike does not include the right to cause mayhem, does not include the right to bliksem your fellow colleague or anybody else, does not encompass the right to damage property and so forth. That is misconduct during strike action. It doesn't mean that if you go out on strike, you can do what you want. Right? You are simply withdrawing your labor. You cannot go and cause mayhem. And that's where a lot of people get dismissed, is not because they went out on strike, is because of their conduct during the strike. All right. Any questions on that? Okay, let's go on. Now, we were talking about trade unions, and I just want to round this off as follows. You know, trade union membership translates into a lot of money. And let me give you a typical example. In the mining industry in South Africa, let's assume we have 300,000 workers. All right, and each worker belongs to a trade union, and they've got to pay 50 rand. Let's just say minimum amount of 50 rand a month in terms of union subscriptions. It becomes 15 million rand a month simply in union fees. Okay, so union membership translates into money for the unions. So you do find, and we have found, and it has happened in the mining industry a number of years back, where there was this bitter fight. Bitter is probably an understatement. It was a deadly fight for membership in the mining industry. Just to give you a little bit of history, the National Union of Mine Workers, NUM, or NUM as they call them, had always been the union of choice in the mining industry. There were other one or two smaller unions, but they were insignificant as compared to the NUM. And there was a particular person, Mr. Joseph Mtundra, who was a union official at NUM. And at some point he had left, or as a result of certain disagreements or whatever else, he had left NUM, and he had decided to open up his own trade union, which they call AMCU. All right. And what AMCU started doing, AMCU started getting membership in the mines and taking away membership from NUM. And this was a very bitter fight where people had lost their lives. Okay. Because trade union membership, the more members you have, the more money you have, number one, in terms of being able to do union activities. But also it gives you greater power in an organization. So what happens when trade unions come into an organization is that they establish what they call a bargaining forum. This is a forum where the employer sits and the trade union sits, where they negotiate, right? They develop a constitution for the bargaining forum. And in that constitution, they talk about thresholds for when unions are entitled to enter the bargaining forum. Okay, so they may say a union must have 20% members in this bargaining unit, or they must have 30% members in this bargaining unit before they are allowed entry into the bargaining unit, okay, into this bargaining forum to be able to negotiate. If they don't meet, if a union wants to come in and doesn't have that percentage, they won't be allowed to enter this bargaining forum to negotiate. Okay. Now, what had happened in the mining industry is that NUM had entered into an agreement with the employer where they also set thresholds. And I think the threshold was 30%. So you needed to have, if you were a union and you wanted to come into this bargaining forum, you needed to have 30% of members in a particular bargaining unit to be able to gain entry into this bargaining forum. All right. And when AMCU was established, they started taking membership from the traditional NUM membership base. And a lot of people went over to AMCU. In certain minds, it happened as such that NUM no longer met the threshold that they had set themselves to gain entry into this bargaining forum. That means that they fell below the 30% of membership. And what had happened then is that AMCU had gained membership above or 30% and above. And they then went to court and said, court, look, NUM no longer meet the threshold. The employer is now obliged to kick them out of the bargaining forum and to accept us as AMCU now as the bargaining agent now. And we must gain entry into this bargaining forum. And the court at that stage gave, I think, NUM a month in order to show and verify membership to see whether or not they would remain in that bargaining forum or not. Okay. So you'll see that in certain industries where you have competing unions and strong unions, they vie for membership. Because membership means a lot. It means money and it does mean power. Now you'll find in mines and in certain other industries, you have what we call full-time shop stewards. Now, full-time shop stewards are employees of the company who've been elected by fellow employees of the company to become the shop stewards of the company. However, all they do is trade union activities in the company. That means that there's so much issues in the company that all they attend to is trade union activities. Even though they're employees, they get paid by the employer party, but all they do is trade union work in the organization. So there may be lots of grievances, there may be negotiations, there may be disciplinary inquiries. There's so much of them that they become full-time, that all they do is union activities. All right, so you do find that a lot of them in the mines, that you do find full-time shop stewards. They call them full-time shop stewards. The thing with full-time shop stewards is every 2 years or 3 years, depending on the union constitution, members, employees will elect shop stewards. So if you were a full-time shop steward now, we go to an election and somebody else gets elected as a full-time shop steward. You are no longer a full-time shop steward. You now go back to your original work that you were employed to do. Okay, so you no longer enjoy the benefits, or if there are any benefits, of being a full-time shop steward. You must go back to your original work. All right, so you do have full-time shop stewards in organizations. Okay, and their primary function is to deal with trade union activities, representation of union members within an organization, attending to meetings, health and safety meetings, attending to employment equity meetings, attending to grievances, attending to disciplinary inquiries, and dealing with general employee-related issues with an employer. You act on behalf of the union, you act on behalf of the members of the union with an employer, and that's your job primarily. But you are an employee of the company. All right, for as long as you're a full-time shop steward, that's all you'll do. The minute you're no longer a full-time shop steward, you go back to the original job that you were employed to do. Okay, all right. It's now 10:40. Can we take a 10-minute break, Cecilia? And we're back at 10:50, and then I'll carry on for about half an hour or so, and then we can end for the day. Is that fine? Cecilia?
Yes, that's fine, sir.
That's fine. So we just break for 10 minutes. I'll see you at 10:50, right?
Okay.
Okay, good. Hello. Cecilia, are you there?
Yes, sir.
Okay. All right. Good. I'm going to be sending, sorry, I just need to inform you. I'm going to be sending an email to the school. I may not be able to lecture on Wednesday morning, but we'll try and reschedule Wednesday's lecture because it's Eid. It's my Eid on Wednesday, but we will do a lecture tomorrow as well. And then we'll try and reschedule Wednesday's lecture for another day, depending on how we go. All right. So just be aware that there may not be a lecture, or at least a label or lecture on Wednesday. All right. Okay. Good. Are there any questions so far? Anybody want to ask anything? Let me just take a few names. Let's see. Is it Tonique Gous? Oh, Tonique Gous is not there, is it? Tonique, who else is there? Cecilia, any questions from your side?
I have a question, but I don't know exactly how to phrase it.
Just phrase
Okay.
it.
So here's a situation where the workers have decided they're going on a strike. Can they decide to refuse entry the employer knowing that they should be replacement of labor?
Okay, so they refusing entry of those employees who are replacement labor.
Yes, together with the employer, like they block the entrance, the gate to
They
someone.
can't do that. That's a misconduct.
Okay.
So they cannot do that. Okay, so whilst theoretically they cannot do that, one of the difficulties you will find in a strike, okay, is that people feel very intimidated. Okay, so even the replacement labor wouldn't want to go in for fear that there may be repercussions. And look, there has been strikes, and I've been involved in a few of them, where people who went to work, even though they were employees, not even replacement labor, they went to work and they were assaulted. Okay, they were assaulted either going to work, assaulted after work, assaulted on the train, assaulted at home. So people are afraid, especially if you have a very belligerent, you have a very, how can I put it? You have striking employees who are very vociferous. They look like they're angry. They can do certain things to you. So you do find that there is fear. There is fear. For both employees who want to go to work and replacement labor. Okay, unfortunately, some of the strikes that we do have in this country turn violent. All right. Theoretically, they should not be blocking entrances. Theoretically, they should not be assaulting anybody. But in practice and reality, it does happen that people do get assaulted in these strikes. I must be honest with you. I've been involved in a few. I chaired a particular disciplinary inquiry. Maybe I'll share this with you, where big company, employees went out on strike. The union had taken employees out on strike. Some employees who did not want to go out on strike decided to go to work, and when they came out, they were followed and they were assaulted, and some of them were assaulted really badly. And the employer party then instituted disciplinary action against, I think there were 2 shop stewards who were involved in that, 3 shop stewards who were involved in it, and 4 other employees. And the evidence that had come out seemed to be quite clear. Video footage, number 1. Number 2, doctor's reports. This employee came to testify when he was assaulted. So it does happen. Okay, so unfortunately, strikes sometimes do take a very violent disposition. They're not characterized by peaceful protest and so forth. So, Cecilia, to answer your question, Theoretically, no. Practically, people are afraid. Okay, sometimes employers will shut down that entire business. Not even those who want to come to work, tell them don't come to work. It's too dangerous to come to work because one never really knows what can happen. And then you do have those strikes which are extremely peaceful. There's no issue. People stand, they protest. It's peaceful. They don't interfere with anything, and so forth. So yes, okay. Does that answer your question, Cecilia? Yeah, Cecilia, have I answered your question? Yeah. Okay. Cecilia, are you there?
Yes, sir, I said yes, I got the answer. Thank you.
Okay, sorry, because I didn't hear you. You went very quickly onto mute.
Oh, okay.
Good. Are there any other questions?
Yes, I do have a question, sir. So, let's say, what was I talking about? Hey, I have this bad tendency. I'll remember my question now.
Okay. All right. Anybody else? Anybody else have a
I was
question?
talking about,
Yes.
I wanted to ask about replacement labor.
Yeah.
The employees who work as replacement labor employed on a temporary basis for that, I don't know, period or short period.
Yes.
Oh, okay.
Yeah. So they essentially only employed for that. So it's like a fixed term or temporary basis. Okay.
Oh, okay.
Only for that period of time. Because you must remember, those striking employees are still employees. The minute the strike is over, they go back to work. Okay. So replacement labor would just be temporarily in place. Now that brings me to another thing, and thanks for raising that. You have different types of employment relationships. One, you have a permanent employment relationship where a person is employed permanently. Okay. Then you have what we call fixed term contracts of employment. Now, fixed term contract of employment can be in two respects. One, it could be for a fixed duration of time. That means you're employing somebody for 6 months only, or you're employing somebody for 3 months only, or for a year only. It's fixed in terms of time. Okay. Or you can also have a fixed term contract of employment in terms of project. So I'm employing you for the duration of a particular project. And once that project has ended, so too will your employment. So you do get fixed term contracts of employment. All right. So you have a permanent employment, you have fixed term contracts of employment as well. Now, our law would assume permanency of employment unless there is something that is written down that says it is not permanent. So if you do get employed as a fixed term employee for duration of time or for a project, then that must be stipulated in writing to say that you're employed for a fixed term period of time. All right. Now there's another thing. You know, you probably have come across these labor brokers, okay? Labor brokers or temporary employment agencies. So they provide employees to companies who want particular types of skill for a particular duration and so on and so forth. Now, what had happened over the years is that people were employed by labor brokers, but there is no security when you're employed through a labor broker. So how it would work is that I would go to a labor broker and say, listen, yeah, I need 10 people, and this is the type of jobs that I want to have done. So please provide me 10 people. What would happen is that the labor broker would then go onto its database and say, these are the guys that have the skills to do this type of thing. We call them in. And this is how it worked practically through some labor brokers. They would call you in and say, listen, you don't have a job. We've got a job for you. You need to start now. Here's the contract. Just sign it. And we'll tell you it's for 3 months or whatever else have you. We'll sign it quickly. We'll send you off to this employer party. Now, I, as the employer party, I got you guys there. You guys are working. I don't like Tabiso. Tabiso is one of these guys who is there from the labor broker. I don't like Tabiso. All right. I phoned the labor broker. I said, listen here, I don't like this Tabiso fellow. Please remove him. from my workplace. What the labor broker would then do is would call you in, all right? The contract that you had signed, they had not put in a termination date there. They would then enter today's date as the termination date. Do you understand? You go in there, they tell you, you know what, you're no longer employed. You Tabiso will say, but you told me I'm employed for 3 months. They say, oh, what? Look here. Here's that contract of yours. It says here, today's date. They've written it in without you knowing, because when they got you in, they told you quick to go to work. And it happened too often like that. But there was no security of employment for anybody, for that matter, through the labor brokers. And they tried to address this issue because it was happening too often. You know, people were going there for 1 week, working for 3 weeks. There were other instances where people worked fine and it wasn't a problem. But there was just so much insecurity that legislation had to come in to deal with these type of things. And then there was an amendment or an insertion into the Labor Relations Act where there was a deeming provision now. I must get to that section where if a person is employed through a temporary employment service, which includes the labor broker, okay, which is the labor broker basically. If that person is employed for more than 3 months, that person is deemed now to be the employee of that employer. Do you understand? So if I was the company, I went to a labor broker, I got Tabiso through a labor broker, and he's worked for more than 3 months. Tabiso is now deemed to be my employee as well. All right? And that was a way in which they could try and give security of employment to people who were employed through labor broking services. All right? Good. Any other questions?
Sir,
Yes.
come across this statement and it reads, employees who are entitled to engage in a protected strike after the notice to the employer must give at least 48 hours notice in writing to the commencement of the strike, but must be given to the employer unless the employer is the state, and then of which they will be entitled to 7 days notice. Why do you have to have 7 days notice?
Sorry?
This one where it says the employees have to give the employer 48 hours notice.
That's the private sector.
Yes.
And
Then
then
it says if it's the state, then it has to be 7 days notice.
yes.
So why give the state 7 days notice and then the private only 48 hours?
Okay, look, because the state runs and it needs to look after the country. So the state needs to be able to put in contingency plans to be able to ensure that if there is a disruption through strike action, that they are able to deal with whatever issues that the citizens of the country require them to deal with. Do you understand? So there is that distinction between private sector and the state. In the private sector, they give you 48 hours notice. I mean, that's just how basically the legislation has been drafted, because both the private and the public sector need to have contingency plans put into place. They need to know when the strike is going to be commencing and so forth. So they've just given the state 7 days to be able to put in contingency plan, because you must remember the wheels of state move very slowly. That's why there's the 7 days. And that's the only reason behind it. I mean, so it's just simply that the state is given a longer time to be able to prepare and be ready and to have contingencies put into place. Whereas the public sector, the private sector only has 48 hours notice. So it's just simply that. There's no particular reason apart from that you need to give the state a little bit of a longer period of time to put contingencies into place. All right.
Okay. Another question. Who issues the non-resolution certificate? Is it a CCMA or a bargaining, whatever?
Yes. So if you belong to a bargaining council, you would refer your matter, your mutual interest matter, to the bargaining council. They would issue it. If you don't belong to a bargaining council, you go to the CCMA and they would issue it. So it's a commissioner that issues it, either at the bargaining council or at the CCMA, depending on which industry you're in and whether you're covered by a bargaining council, or if you're not covered by a bargaining council, then the CCMA would issue it. All right, so it's a conciliating commissioner who issues it.
Okay. Can you lastly address the one of jurisdiction between CCMA and Labor Court? Can you discuss the jurisdiction?
Okay, so I will deal with jurisdiction tomorrow, because the Labor Court has specific jurisdiction on certain types of matters, and the CCMA and Bargaining Council have jurisdiction on certain types of matters. For example, certain types of retrenchments, if they are large-scale retrenchments, they must be all first be conciliated at the CCMA. Then you decide whether to go to arbitration at the CCMA or Bargaining Council, or alternatively Labor Court. So it's only after conciliation that that election is made. Okay. However, having said that, if you want to interdict a strike, if a company believes that the strike is illegal, or they want or unprotected or whatever, and they want to interdict it, they can go directly to the Labor Court. The Labor Court has jurisdiction over unprotected strikes. CCMA doesn't have jurisdiction. Okay, so we'll deal with jurisdiction tomorrow in different types of disputes. All right, but interdicts in terms of employment law, you go directly to the Labor Court. You don't go to the CCMA. Right? Different types of terminations of employment, depending on the type or the nature of the termination, CCMA may or may not have jurisdiction. In certain categories also, there's a differentiation between the number of employees who may be dismissed, where the CCMA can have jurisdiction or where the CCMA doesn't have jurisdiction, especially in retrenchments. If it's more than 10 employees who are retrenched, then it's the Labor Court who will have jurisdiction. If it's less than 10, or an employer employs less than 10 people and people were terminated there as a result of a retrenchment, the CCMA can have jurisdiction. They also have provisions for certain types of disputes in terms of the Employment Equity Act, where parties can agree that the CCMA has jurisdiction. If parties don't agree, then the Labor Court has jurisdiction. Okay, but we'll deal with some of them tomorrow. Right, and I'll give you examples of them. Okay. Good.
Okay.
Good. Anything else? Anybody else? All right. Let's do this. I think let's call it a day for today. Tomorrow we'll start with unfair labor practice, individual employment law, unfair labor practice, and terminations of employment. And I'll take you through the various categories of terminations and the ones that we deal with very often. And I'll explain to you how that works. We'll also then go and deal with the labor court. We'll deal with reviews. We'll deal with condonation applications. We deal with rescission applications and so forth. All right. So I'll see you tomorrow at 8:30. Okay.
Thank you.
All right. See you guys tomorrow. Please be safe out there.
Thank you, sir.
Okay. Bye. See you
Thanks.
tomorrow.
Bye.
Bye.